Amicai's point. He says that Congress didn't go into this act to impose minimum coverage. They went into the act to have a different purpose, i.e., to get people coverage when they needed it, to increase coverage for people, that this is only a tool. But other states, going back to my original point, that there are other tools besides minimum coverage that Congress can achieve the same goals. So if we strike just a tool, why should we strike the whole act when Congress has other tools available?
Okay. Mr. Chief Justice, I'll make 4 points in rebuttal, but I'll start with Justice Sotomayor's question, which is to simply say this isn't just a tool, it's the principal tool. Congress identified it as an essential tool. It's not just a tool to make it work. It's a tool to pay for it, to make it affordable. And again, that's not my characterization. That's Congress's characterization in finding I on page 43A of the government's brief. Now, that brings me to my first point in rebuttal, which is Mr. Kneedler says quite correctly, tells this Court, don't look at the budgetary implications. Well, the problem with that, though, is once it's common ground that the individual mandate is in the statute, at least in part, to make community rating and guaranteed issue affordable, that really is all you have to identify. That establishes the essential link, that it's there to pay for it. You don't have to figure out exactly how much that is and which box. I mean, it clearly is a substantial part of it because what they were trying to do is take healthy individuals and put them into the risk pool, and this is quoting their finding, which is in order they put people into the market which will lower premiums. So that's what their intent was. So you don't have to get to the final number. You know that's what was going on here, and that's reason alone to sever it. Now, the government, Mr. Kneedler, also says there's an easy dividing line between what they want to keep and what they want to dish out. The problem with that is that, you read their brief and you might think, oh, there's a guaranteed issue and a community rating provision subtitle in the bill. There's not. To figure out what they're talking about, you have to go to page 6 of their brief, of their opening severability brief, where they tell you what's in and what's out. And the easy dividing line they suggest is actually between 300G-A1 and 300G-A2. Because on community rating, they say that A1 goes, but then they say A2 has to stay, because that's a way that we'll have some sort of kind of Potemkin community rating for the exchanges. But if you actually look at those provisions, A2 makes all these references to A1. It just doesn't work. Now, in getting back to an inquiry that I think this Court actually can approach, is to look at what Congress was trying to do. You need look no further than the title of the statute, Patient Protection and Affordable Care. I agree with Mr. Farr that community rating and guaranteed issue were the crown jewels of this Act. They were what was trying to provide patient protection. And what made it affordable? The individual mandate. If you strike down guaranteed issue, community rating, and the individual mandate, there's nothing left to the heart of the Act. And that takes me to my last point, which is simply this Court in Buckley created a halfway house, and it took Congress 40 years to try to deal with a situation when, contrary to any time of their intent, they had to try to figure out what are we going to do when we're stuck with this ban on contributions, but we can't get at expenditures because the Court told us we couldn't. And for 40 years they worked in that halfway house. Why make them do that in health care? The choice is to give Congress the task of fixing the statute, the residuum of the statute, after some of it struck down, or giving them the task of simply fixing the problem on a clean slate. I don't think that's a close choice. If the